wire fraud under 18U. C. 1,343 and mail fraud under 18U. C. 1,341 are two of the most commonly used federal fraud statutes. They cover a wide range of allegations involving misrepresentations sent by email, electronic systems, phone communications, or the U.S. mail. In Bakersfield and throughout Kern County, these charges often arise in industries where billing, reporting, and compliance are complex, especially oil field services, agriculture, public contracting, and relief programs. In Kern County's economy, ordinary business disputes can quickly become federal criminal cases. Oil field service contractors may face scrutiny when electronic invoices for maintenance or production work are later described as inflated or unauthorized. Agricultural cooperative operators and program participants may be accused of fraud when electronic submissions to government programs involve reporting rules that are unclear or open to interpretation. In many cases, the real issue is not a scheme to steal, but a disagreement over billing standards, contract expectations, or compliance requirements. A major problem in federal fraud cases is count multiplication. Prosecutors can turn one business dispute into many criminal counts. Every email, invoice, wire transmission, portal submission, or mailed document allegedly used to further a scheme can be charged separately. In a Kern County oil field or agricultural matter, that can mean dozens of counts based on conduct that would otherwise be described in only a few sentences. Even when sentences may run concurrently, the number of charges creates intense pressure during plea negotiations. 18U. C. 1,341 and 1,343 elements in Kern County cases. To convict someone of wire or mail fraud, the government must prove several essential elements. 1. A scheme or artifice to defraud. This means a plan to obtain money or property through false or fraudulent pretenses. Federal courts interpret this broadly, and the government does not need to show the scheme actually succeeded. An attempt may be enough. In Kern County oil field, agricultural, and public contracting cases, prosecutors often characterize billing disputes, contract disagreements, or reporting problems as fraudulent schemes from the very beginning of the relationship. 2. Knowing participation with intent to defraud. This is one of the most important elements. The government must prove the defendant knowingly participated and intended to deceive. A good faith belief in the truth of the statements made, or in the legitimacy of the billing or reporting practice, can defeat this element entirely. That is especially important in Kern County industries, where practices are often shaped by custom, oral agreements, informal approvals, or complicated compliance systems. 3. Use of the mail or wire communications. The government must also prove that mail or wire communications were used in furtherance of the alleged scheme. This can include emails, electronic invoices, online portal submissions, mailed records, or phone calls. Each individual use can become a separate count. In a business environment where a single billing cycle may involve multiple submissions and confirmations, one dispute can produce a large federal indictment. The count multiplication problem in Kern County. This issue is especially serious in local industries. A Kern County oilfield services case may involve a separate wire fraud count for each invoice, billing report, or electronic submission. Agricultural program cases may involve separate counts for applications, certifications, follow-up emails, and payment-related communications. Even if the sentence is not stacked count by count, the volume of charges increases risk, cost, and pressure. That is why every count should be examined individually for legal sufficiency, intent, and connection to any alleged scheme. Penalties. Standard wire and mail fraud charges carry penalties of up to 20 years per count. If the case involves a financial institution or certain federally declared disaster programs, the maximum can rise to 30 years per count. In In practice, the federal sentencing guidelines often turn on the alleged loss amount, which can significantly affect exposure in sentencing. Wire and mail fraud in Kern County's business environment. Oil field services and production billing fraud. Kern County's oil industry creates frequent exposure to wire fraud allegations. Contractors may be accused of submitting inflated invoices or charging for work not performed through operator billing systems. But oil field billing is rarely simple. Deliverables may be affected by site conditions, informal work orders, oral approvals, shifting production demands, and long-standing industry customs that do not always match written contracts. In many of these cases, the defense focuses on the full context of the business relationship. A disputed invoice is not automatically fraud. If the contractor believed the billing reflected authorized work, standard practice, or services actually rendered, that good faith matters. Agricultural cooperative and government program fraud. Kern County's agricultural sector also generates fraud investigations, particularly where federal or state program submissions are involved. Cooperative accounting, subsidy reporting, and compliance filings can be highly technical. Honest disagreements often arise over what must be disclosed, how production should be classified, or what qualifies under program rules. When prosecutors turn those issues into criminal cases, the defense often centers on ambiguity. If the reporting rules were genuinely unclear, or if the defendant believed the submission was proper, that can directly undermine intent to defraud. PPP and pandemic relief fraud. The Eastern District has prosecuted PPP and EIDL cases involving Kern County businesses. Many businesses applied during a time of uncertainty, relying on changing guidance and confusing eligibility criteria. In those cases, the defense often focuses on whether the business owner genuinely believed the application was accurate and that the business qualified under the rules in effect at the time. Water district and public agency fraud. Kern County's public agencies and water districts also generate fraud investigations when procurement, vendor payment, or contract compliance issues are framed as false submissions. These matters can involve technical rules, layered approval processes, and uncertainty over what procedures were authorized. Not every irregularity is criminal. Many are civil, administrative, or contractual disputes rather than intentional fraud. Where these cases are prosecuted, federal wire and mail fraud cases arising from Bakersfield and Kern County are typically prosecuted in the U.S. District Court for the Eastern District of California, Sacramento Division. U.S. District Court, 501 I Street, Sacramento, CA 95814. U.S. Attorney's Office, 501 I Street, Suite 10, 100. Sacramento, CA 95814. Because these cases are handled in federal court, early strategic defense work is critical. Defense strategies in Eastern District Kern County cases. Good faith defense. Good faith is one of the strongest defenses in fraud cases. If a person genuinely believed that billing, reporting, or compliance actions were accurate or authorized, that belief can defeat the intent element. In Kern County, this often involves showing industry custom, oral approvals, prior course of dealing, ambiguous rules, and contemporaneous communications supporting the defendant's understanding. Challenging the scheme theory. The government often tries to package a messy business dispute as a fraudulent scheme. The defense can counter that by showing a legitimate business purpose, efforts to perform, breakdowns caused by external factors, and the absence of any pre-planned deception. A billing conflict, compliance error, or contract dispute does not automatically become federal fraud. Loss calculation challenges. Loss amount can drive sentencing exposure, so it must be examined carefully. In many cases, the government overstates loss by ignoring value actually delivered, services performed, offsets, or legitimate contractual disputes. Reducing the alleged loss can make a major difference in the advisory guideline range. Pre-indictment intervention. If a person learns they are under investigation, receives a target letter, or gets a grand jury subpoena, the time before indictment can be critical. Presenting documents, context, and evidence of good faith before charges are filed can influence the government's decision-making and narrow or prevent charges. If you are contacted by the FBI about fraud in Bakersfield, if federal agents contact you, take the situation seriously from the start. Do not agree to an interview without speaking to federal defense counsel first. Do not destroy, alter, or delete records, emails, invoices, program submissions, or internal communications. Preserve documents that show the good faith basis for your conduct, including contracts, authorizations, notes, prior communications, and evidence of industry practice. If you receive a target letter or subpoena, respond quickly and carefully. Early decisions can affect the entire course of the case. Wire and mail fraud defense across Kern County. These cases affect clients throughout Kern County, including Bakersfield, Taft, Shafter, California City, Arvin, Delano, Maricopa, McFarland, Ridgecrest, Tehachapi, Wasco, and surrounding communities. Federal investigations often begin quietly, but once charges are filed, the consequences are serious. Frequently asked questions. Can an oil field billing dispute become a federal wire fraud case? Yes. If a contractor is accused of sending inflated invoices through an electronic billing system, the matter can be referred for federal prosecution. But the government still must prove criminal intent. A genuine belief that the billing was accurate or authorized can be a complete defense. Are PPP loan fraud cases still being prosecuted? Yes, these cases are still being brought, and applications submitted in 2020 and 2021 may still fall within the statute of limitations. Many defenses focus on uncertainty in program guidance and the applicant's good faith understanding of eligibility. Why do wire fraud cases sometimes have so many counts? Because each email, invoice, submission, or wire transfer used in furtherance of the alleged scheme can be charged separately. One business dispute can become many federal counts very quickly. Wire and mail fraud cases in Bakersfield are rarely as simple as prosecutors make them sound. Many start as business disputes, billing disagreements, or compliance questions in industries where the rules are complex and the facts are layered. In federal court, the key issues are often intent, context, and whether the conduct was actually criminal at all. If you are being investigated or have been charged with wire or mail fraud in Bakersfield or anywhere in Kern County, speak with a federal defense attorney as early as possible. Early action can protect your rights, preserve key evidence, and shape the defense before the case moves forward.